Dear viewers, I now want to explain another important aspect of judicial activism, and more particularly about the public interest litigation which we had been discussing so far. Desai and Muralidhar, two senior advocates of the Supreme Court, in a recent article identify four major areas, broad areas, in which Indian judiciary has been able to make significant pronouncements. These are, according to them, 1. Human rights, 2. Good governance and public accountability, 3. The judiciary, and 4. Environment. These are the four areas into which the Supreme Court and the High Courts have made significant pronouncement in the field of public interest litigation. So these four aspects need separate discussion. First, public interest litigation and human rights. In fact, public interest litigation started here in India in the late 70s and early 80s in order to protect the fundamental rights, the human rights of the downtrodden masses, the disadvantaged sections of the society. And in this phase, particularly several aspects, the rights of the under trial prisoners, the prisoners who are languishing in prison, they have also their rights, and these rights have to be protected. The rights of the bonded laborers, the rights of the unorganized laborers, the rights of the pavement dwellers. Through public interest litigation, the judiciary tried to protect the rights of these oppressed sections of our community. So in this field, in the field of human rights, the public interest litigation has a very useful role. So the public interest litigation started with the protection of the human rights of particularly of the downtrodden masses. Secondly, in the second phase, in fact, S.P. Sathe, another legal jurist and a former professor of law at Bombay University, according to Sathe, the second phase, in the early 80s, the emphasis was shifted from human rights to good governance and public accountability. Why? Because in this phase, one finds a significant increase in corruption, scandals, scams in which the top-ranking politicians and bureaucrats were allegedly involved. So, in order to tide over this problem, and in order that right to information is available to all, in order that administration can be made more transparent and accountable, a number of public interests litigations were brought in the High Courts and the Supreme Court to resolve the issue. And as a result, the Supreme Court tried to free the investigating agencies like CBI, like CVC, like ED, Enforcement Directorate, to free them from the control of the executive so that they can act independently without fear or favor. So in this phase, good governance and public accountability, on these aspects the Supreme Court gave due importance. And the third phase, which in fact I have already discussed in my previous lectures, when I was considering the appointment of Supreme Court and High Court judges and transfer of High Court judges from one state to another, I said that the judiciary, particularly since the 90s, has been playing a very pivotal role in the selection of judges of the Supreme Court as well as of the High Courts. And this was possible as a result of a number of public interest litigation cases. Two particular cases must be taken note of. One is S.P. Gupta versus Union of India, the first public interest litigation case on the appointment of judges of the Supreme Court. This was the first case regarding judiciary. This case was in 1982, S.P. Gupta versus Union of India. In this case, of course, the judiciary, the highest judiciary, the Supreme Court, was of the opinion that the judiciary must not be given primacy. The Chief Justice of India must not be given primacy. It is the prerogative of the executive, the President, along with the Council of Ministers, to appoint the judges of the Supreme Court and High Courts. But subsequently, in the second judge's case, again that was a public interest litigation case, that is SC Advocates on Record versus Union of India 1993. Here, the Supreme Court overruled its earlier decision, rejected its earlier decision, and said that in the case of selection of judges of the Supreme Court as well as of the High Courts, the opinion of the Chief Justice of India must be given primacy. So, here too we find that public interest litigation is related to judiciary also. And finally, Desai and Muralidhar point out that in environmental cases also, public interest litigation has a role to play. In fact, the Supreme Court and High Courts have been playing a very important role in environmental issues through public interest litigation. In fact, two eminent economists, Jean Drèze, a Belgian-born Indian economist, now he is an Indian citizen working in the Department of Economics, Allahabad University, and Nobel laureate Amartya Sen, in one of their books, observed that during the 90s of the last century, that means in other words, during the last decade of the last century, there was an unprecedented wave of environmental cases through the means of public interest litigation. All these cases wanted to free the environments. Particularly, there are several instances can be cited. For instance, the wastes from the tanneries or from the chemical factories pollute the rivers. So, public interest litigation were brought in the Supreme Court and High Courts in order to make people conscious of and to solve the problem of environmental matters, and particularly conservation of forests, protection of forests, to maintain ecological balance, etc. So these are the four broad areas into which we find the Supreme Court intervened through public interest litigations. Now, the discussion that have been made so far makes it clear that there are two important components of judicial activism. We find that there are two important components of judicial activism. One, basic structure doctrine. Two, public interest litigation. So these two components reflect common features. As already discussed, the purpose of basic structure doctrine is to limit the power of Parliament, unlimited power of Parliament, so that Parliament, by using its power of amendment, cannot destroy the Constitution. So, judiciary has tried to limit the power of Parliament, and thereby the judiciary has strengthened its own position. Secondly, another component, that is public interest litigation. There are scattered centers of power, like police station, like prison, like different homes. So they are the agents of the states, the public authorities. They may try to exploit the illiterate masses. So in order to combat that, in order to check those unbridled exercise of power by the agents of the state, public interest litigation is necessary. So that is very important in order to check the unbridled exercise of power in different levels of the society, so that the downtrodden masses can get justice. Finally, a number of criticisms have been leveled against the judiciary, that judiciary has become very much powerful. So this is not acceptable. These are some of the criticisms leveled against the judiciary. I don't want to go into the details of all those criticisms. I must point out one or two things here. One, it is alleged that judiciary is already overloaded with cases. So it is not worthwhile for the judiciary to accept public interest litigation. That will complicate the matter. This is one such allegation. But the most important allegation is that of overreach. That is, judiciary has become overactive. It is not simply active, it has become overactive. It has entered into the domain of the other. Every organ of the state, the executive, the legislature, the judiciary, all these organs have their own boundaries, have their own jurisdictions. But the judiciary recently, by using its power, has been trying to overstate its limits, has been trying to intrude into the domain of the other. That is a very important criticism made even by eminent jurists of our country, that this is a very dangerous trend, that judiciary has been trying to encroach into the arenas of the other organs of the state, that means the executive and the legislature. Finally, I must conclude by saying that these criticisms are not baseless. But there is no denying the fact that judiciary has been playing a very good role in recent years. As a result of the public interest litigation, the people have become aware of some of the crucial problems of our society. Only through the intervention of the judiciary in the public interest litigation cases. For instance, the problems of slum dwellers, problems of pavement dwellers, problems of bonded laborers, problems of environment, all these crucial issues which afflict our country has been known to us through this intervention of the courts in the public interest litigations. We cannot deny this role of the judiciary. However, we mustn't think that judicial activism is a panacea for all evils. that it will solve all our problems with which we are afflicted with. It can't solve all our problems. Judiciary plays a useful role, undoubtedly, but it cannot solve all the problems of the society. So we need a comprehensive approach, an approach by which we shall try to understand the problems comprehensively, and a concerted social and political movements, through concerted social and political movements, through public discussion and debates only, the problems of the society can be resolved. Here, judiciary can play a part only, an important part only, but judiciary cannot solve all the problems. So, let me sum up what I have already discussed. I said how the judiciary has been developed progressively from a passive positivist court to an active institution. And I explained the meaning of judicial activism. I also pointed out that as a result of the two extraordinary judicial innovations, that is, basic structure doctrine and public interest litigation, judiciary has been able to play an active, dynamic role which the framers did not imagine it to be. Then I explained the meaning of basic structure, how it was evolved in the wake of Keshavananda Bharati case, and how the powers of the parliament were curtailed, and thereby how it helped to strengthen the hands of the judiciary was discussed as well. Then I considered another very important component of judicial activism, that is public interest litigation. I explained at the outset, in fact I quoted Rudolph and Rudolph to show the shift from one perspective to another in the 80s, from a conflict between judiciary and parliament to cases that attract public interest litigation. And then I explained the meaning of public interest litigation and its essential features. And I also pointed out that there are certain broad areas like human rights, good governance, judiciary, environment. In these areas, the judiciary, through public interest litigation, have made significant pronouncements. And then I briefly discussed some of the criticisms labeled against the judiciary for being overactive, and particularly the allegation that it has overstepped its limits. It has intruded into the arenas of the other organs like the executive and legislature has also been discussed. Finally, I said that despite all these criticisms, the judiciary has been playing an excellent role. It made the people conscious of the problems that afflict our society. We couldn't have known the different crucial problems of society, the problems of the bonded laborers, problem of the pavement dwellers, unorganized laborers, custodial deaths, arbitrary arrest and detention. All these problems came to light through the intervention of the judiciary in the public interest litigation cases. That cannot be denied. However, one must also note that judiciary cannot be a panacea to all the evils in the society. So, to eradicate the problems, what is needed is public discussion and debate, and concerted social and political movements. These will help to solve the crucial problems of our society. That's all.